Good evening, dear participants. I'm glad to welcome you on this webinar organized jointly by the Ukrainian Arbitration Association and Swiss Arbitration Association on how to become a good arbitrator. My name is Elena Pripolinska. I am the president of the Ukrainian Arbitration Association, and I am very happy to introduce our today's speakers, all from Switzerland, from Swiss Arbitration Association. And I will start with Urs Weber-Stecher, who is an independent Swiss arbitrator and mediator with more than 25 years of experience in dispute resolution. He is a member of ASA board and member of the academic council of the Swiss Arbitration Academy. He is a member of the ICC Commission on Arbitration ADR and the Swiss ICC Commission Swiss ICC Commission on Arbitration ADR. And he has been a lecturer for international arbitration at the University of Zurich Law School for more than 20 years. Our next speaker is Nadia Yaisli, who is a partner in Better Career based in Zurich and co-head of the firm's international arbitration practice. She represents clients in international arbitration and litigation and sits as an arbitrator. She is a member of the nomination committee of ICC Swiss Commission on Arbitration and ADR and proposes arbitrator candidates to the ICC court in Paris. Nadia is also a member of the Swiss Arbitration Association. And last but not least, Paolo Marzolini, who is a founding member of Patocchi and Marzolini law firm, specialized in arbitration and based in Geneva. Paolo acts as counsel representing clients and sits as arbitrator in Switzerland and a number of other jurisdictions under various set of rules. He has been involved in several major international arbitration, and his practice includes mediation and dispute boards. Paolo has served as a member of the court of the Swiss Arbitration Center since 1st June 2020, and on 1st January 2024, he was appointed secretary to the court of the Swiss Arbitration Center, and he is admitted to the bar in Switzerland and Italy. So with such rich background of our speakers, so I will first ask Urs about Switzerland. So we know that Switzerland is very specific in terms of arbitration landscape, and this is a place where so many independent arbitrators are based. And this is a very important and popular seat of arbitration. So my first question is, why Switzerland is so special, whether there are any reasons for that. Urs, the floor is yours.
Thank you, Olena, and welcome to everybody. I'm very happy to be part of this webinar on how to become a good arbitrator. And I think irrespective of where you are, whether you are in Ukraine or in Switzerland, this is possible to become a good arbitrator. And as Olena said, she thinks that is interesting for you also to hear a little bit about the special role that Switzerland played so far in the last century in international arbitration. And I quickly want to guide you through a small presentation. I will share now my screen, and I hope that it works. Just a second.
Yes.
Does it work?
Yeah.
Okay, there are a few topics I want to guide you through very briefly. You see here the 6 topics, and I start actually with the good offices. This is something that started in the early 20th century when Switzerland was providing good offices to parties after the World War I. And that was the time when Switzerland actually became a neutral intermediary in international conflicts. So it also had the role as a protecting power mediator at that time. And this was further consolidated after World War II when it provided diplomatic representation for countries that did not have formal relations with each other. And this role continued to evolve over the years, and Switzerland was hosting numerous peace talks and negotiations over the decades. Just to name a few conflicts that Switzerland was involved, the ceasefire agreement in Sudan and discussions between rebel groups and the government in Colombia, also meetings between rebels and the government in Sri Lanka, and also in Iran's nuclear power program. And in recent years, it also developed into services between rival groups within states. There also Switzerland adapted accordingly to offer services for these groups to help them find solutions. And also in operations that are launched by states, several states, and coordinated by international organizations such like the UN and the EU or the OSCE. It acts also, Switzerland, as a post box. That means it allows both sides to keep relations even if they have very difficult relationships with each other. And obviously one of the most recent examples of such services was the peace conference for Ukraine that was held on Bürgenstock last summer. So there is a very long tradition of Switzerland offering these good offices in the political area. There is also, when you go to the origins of the commercial and investment arbitration, you also find yourself back in Switzerland, because the Alabama claim case of 1872 is considered to be the landmark case, or one of the landmark cases that led to the emergence of international arbitration. So in a nutshell, what was this case about? The US had sought damages from the UK in 1869 for the UK supplying warships to the Confederate Navy during the American Civil War, and with that they infringed their neutrality obligations. And at that time, Europe was also very much in armed conflicts. So they chose Switzerland, Geneva actually, the city of Geneva, as the seat for this arbiter tribunal. And Count Sklopsis, he was the president of the tribunal. And I quote here, cite the quote of him. He said, "In no other country was it possible to avoid all individuals' local suspicion and to be exempt from any possible political influence foreign to the object of the arbitration." So that was actually the reason why they chose Geneva in Switzerland to be the seat of the arbitration. And that was also, or is considered often, as the start of modern public law arbitration that led into commercial arbitration. Also now that Switzerland is a trustworthy venue for such arbitrations. Now, the landscape of Swiss arbitration is basically two very important organizations are the Swiss Arbitration Association. This was established exactly 50 years ago. Today it has over 1,000 members from Switzerland and also internationally. And the goal of this organization is to promote arbitration as an effective method of dispute resolution. There's also a bulletin that is published where you can read a lot of articles on topics in international arbitration and also on the practice of the Swiss Federal Tribunal, which is important in the international arbitration here in Switzerland as well. And then we have the Swiss Arbitration Center. This is actually the institution that is administrating the cases under the Swiss rules. And here you see that we have really a large majority of 78% of international arbitrations. So the domestic arbitration in Switzerland is really at a small end. And then if you look at the languages, it's 65% of the cases are in English. So it's really a very international thing. A third important organization I quickly want to introduce is the Swiss Arbitration Academy. This is linked to the University of Neuchâtel and the University of Lucerne. Together, they offer a course in international arbitration. The Swiss Arbitration Academy was established in 2008, so that's 16 years ago. It has a number over 200 graduates from Switzerland and all over the world. Actually, Paolo is one of our first graduates. And the aim of this institution is to offer high quality education in international arbitration. So if you are interested, please let us know. We can provide you more information about the Swiss Arbitration Academy. Very briefly, what are advantages of arbitration in Switzerland? Actually, the legal framework is important. So the statutory provisions in the Chapter 12 of the Federal Act on Private International Law is quite short. There are only a few articles. They are flexible and simple. So that helps in particular foreign parties to have arbitrations here in Switzerland. And the Swiss judiciary does not really interfere with international arbitration. You know that the only appeal you can make is directly to the Swiss Supreme Court, and this only on very limited grounds. You find the similar grounds in the New York Convention if you want to oppose against an enforcement of an award. And what I mentioned before, an important aspect is political neutrality and the democratic stability in Switzerland, and the more than 100 years history I mentioned before. Then we have several languages we speak. So all of us speak at least two, most of us three or even four languages here in Switzerland. And then there is a long and broad legal expertise and specialization in international arbitration that helps to make sure that arbitrations conducted here are really done in a professional way. Then also, Switzerland is in the heart of Western Europe, so it's easily accessible. The airport is close to the city, and you don't have a long ride from the airport to the heart of the city. And last important point is Switzerland is not known for corrupt practices, so there it's really on a very good ranking in corruption practices indicators. Then the final slide I would like to show you is the key takeaways for you if we look what you could learn from Switzerland. And I think if we look what happened in the recent years, then we see that Ukraine has demonstrated a remarkable resilience, and its commitments to the rule of law remained intact. So the dedication of Ukraine to maintain legal transparency and judicial independence, despite this extreme external aggression, this will help to build trust in the arbitration process, with arbitrations located also in Ukraine. Then obviously it makes sense that the arbitration community in Ukraine makes sure that the arbitration laws are always up to date so that you can ensure consistency with the international standards. And this will certainly make sure that the appeal as a dispute resolution venue is good of Ukraine. Then Ukraine has the accessibility it's in a center location in the eastern part of Europe, so it can really act as a bridge between Europe and Asia. So I think this could be really attractive once this aggression by Russia will be stopped. And Ukraine has also shown a lot of efforts in anti-corruption. So I think if you have successes, then this will also improve yes, that you could have arbitrations in Ukraine. And then I think it's important to make sure that you have training programs, such webinars and international arbitration courses, to make sure that the level of knowledge in this field is really good. And I think if you have all this together, then you have a good basis to build up your own practice as a arbitration practitioner, and in the end also as a arbitrator. I think I stop here, and if you then have questions later on, we can still address some of the topics that I may have just touched upon briefly.
Thank you, Urs, very much for this overview of the reasons why Switzerland is a so specific place, and we indeed have a lot many lessons to be learned from that experience. And I could briefly say that Ukraine, despite the war, and Ukrainian arbitration community is working to improve the legislation framework. Ukrainian courts demonstrate a high support and friendliness to arbitration despite the war. Again, we have very, very good numbers in terms of setting aside and enforcement of arbitral awards in Ukraine. And Ukrainian Arbitration Association regularly organizes different courses, arbitration, school arbitration academy for Ukrainian lawyers. So we are indeed doing that. And the country in general, with the help of Western partners, is working with the rule of law, transparency, and other issues mentioned in your presentation. But indeed, we have a way to go. But that is like a very general framework. Let's talk about people. And because, again, we're talking about arbitrators, how to become a good arbitrator. Of course, you need a good jurisdiction for that, but still, you should have a good personality and probably some skills. And let's ask Paolo and Nadia about that. You have very different profiles and probably very different views on what should be done in order to become a good arbitrator.
Well, thank you so much, Olena. With Nadia, we agreed that I would start. First of all, I'd like to thank for the invitation, the Swiss Arbitration Association, and of course, the Ukrainian Arbitration Association. It's a pleasure to participate in this webinar. So I'm not here to teach anybody. I'm here just to share my views and share my experience. And with Nadia, we thought that a good way to kickstart the discussion would be to share a little bit of our background, how we started our career in arbitration. So how I started over 20 years ago, and I started, I should say so, by chance, by pure chance. Initially, my goal was not to be involved in arbitration. I wanted to do or be involved in international law, but arbitration was not my main objective. And my perception of how the practice of arbitration and in general the field of law has evolved over the past few years is that the situation has changed. We very often receive curricula nowadays of candidates applying to our law firms, which seem to have been thinking about arbitration since they were babies. That was not my case when I was 20 years old or 25 years old. I have to say, and I like to be provocative in my intervention today, that arbitration is now perceived as a cool field of practice. And I think that that stems from a perception in the younger generation that maybe the demand for arbitration practitioner is higher than what the demand actually is in many jurisdictions. And I think that we have to be very clear on that in this respect. But back to my career, I started as an arbitration practitioner at the Milan Chamber of Arbitration, where I acted as counsel for 3 years and a half. As counsel, I was administering cases there. Administering cases at the time, and still is the case at the Milan Chamber of Arbitration, meant that when you were assigned a case, you were acting as secretary to the arbitral tribunal. So that means that at the time, I supervised in 3.5 years over 150 cases, and I participated personally in over 200 hearings. So that gave me a lot of experience, at least for the mainly domestic cases that I supervised back then. Then I met Paolo Michele Patocchi, who later became my boss in Switzerland and my mentor, and I will get back to the importance of mentorship later on. When I moved from Italy to Switzerland in 2007. At the time, I focused my practice mostly to act as counsel and secretary to arbitral tribunals. And as Urs said a short while ago, I was one of the very first participants and students at the Swiss Arbitration Academy, which is an amazing institution which was created around 2007, 2008, if I'm not mistaken, which gave me a very good overview at the very beginning, and a very practical one, which is very important, of the Swiss way of conducting arbitration. So that was the beginning, in a few words, of my career in arbitration. Nadia, the floor is yours now.
Hello, everyone, and thank you as well for the invitation to speak today. It's a great pleasure. So, to me as well, it's a pure coincidence that I ended up in arbitration. I'm happy about this coincidence, but it was never my plan. I initially wanted to become a journalist, and I thought, let's nevertheless study something serious. So I started to study law. And then at some point, I thought, now that I studied law, let's take the bar exam and rather work for a law firm than for a newspaper. But I always wanted to do litigation, so be in court and do the classic lawyer work, or at least to me, that was the classic lawyer work. And then I started with Baron Carr in Switzerland, in Zurich. And I started to work for a partner, Daniel Hochstrasser, who was one of the famous arbitration practitioners in Switzerland. And that's how I became involved and specialized in arbitration and started to like it very much. I must say I'm a bit jealous of Paolo when hearing that you participated in more than 200 hearings, because to me, the hearing is always the highlight. So I should probably have started rather in Milan than in Zurich with a big law firm. But yeah, so that's the way I started. And I think typically you would start as a party counsel. So you work in a firm who does counsel work. That's the typical start of an arbitration career. And with more experience, at some point, you can start to think of how to become an arbitrator. I think it is very difficult to become an arbitrator without having prior experience as a counsel. How did I become an arbitrator, or how did I get my first arbitrator appointment? I think before that, I was exposed to arbitrator work in moot courts. And that would be the first practical tip to everyone, younger practitioners who are interested in arbitrator work. I think it's good to participate in moot courts, for example, the Wismut in Vienna. That was my start to arbitrator work, where I also got to know people like Urs, who is here as well today. Because, for example, the Wismut in Vienna is really a place where you have the opportunity to meet the arbitration community in a very informal and friendly way. I got to meet people like Urs, who then at some point asked me if I wanted to become an arbitrator in moot courts in Switzerland, and that's how you can develop your first experiences in moot courts, and then at some point this may lead to the first real arbitrator appointment. So, Paolo, do you have any tips on how to get the first arbitrator appointment?
Well, thank you, Nadia. I think that the first tip very much echoes what you said. My first tip would be build a very solid knowledge of the substantive law, of your jurisdiction. The jurisdiction can be your jurisdiction of origin, in my case was Italy, or the acquired jurisdiction, which can be Switzerland in my case. But that is something on which I'd like to stress again for the younger generation. There is some sort of confusion sometimes, I have the impression, on the idea that knowing arbitration and the arbitration practice is the ultimate result. In my case, that is not what brings or makes a good arbitrator. A good arbitrator is, first of all, a person who can reach a fair and just decision according to the applicable law, and who knows, of course, the practicalities of arbitration. But the good arbitrator is not the arbitrator who knows only what a Redfern schedule is or what a Kaplan opening is. That's something which is added afterwards. But first of all, build your practice and your knowledge of substantive law. The second tip would be build a solid practice as counsel. This is exactly what Nadia said. A good arbitrator, in my opinion, particularly in commercial cases, is somebody who has a solid practice and who knows what the practice is by acting as counsel. So sometimes, again, I have this impression that younger generation tends to believe that the final goal is to become an arbitrator, but that becoming an arbitrator is a second step, in my opinion. First, you have to be a good lawyer in order to be a good arbitrator. Third, make sure that you are known. Make sure that you are known by the arbitration community means exactly what Nadia was saying. Participating in conferences. I don't know, participating also to academies like the Swiss Arbitration Academies, moot courts, being involved in initiatives, in groups, in association like the Ukrainian Arbitration Association, and knowing people. So building up your network is very important in order to get future appointment. And I think that my first appointment, which I got when I was 32, came because of combination of what I just said before of the tips. Nadia, any further point that you want to add?
Yeah, I mean, I fully agree. I think in addition to the counsel work and the experience and knowledge you do need a network. You do need to know people. And I can also tell that based on my experience now in the ICC Swiss Commission, where I'm in the nomination committee, as Olena just mentioned. There, for the smaller cases, we really try to appoint younger practitioners. And I think this applies to basically all the institutions, that if the case is really small, the institutions try to get a chance to younger practitioners. And there it's really important that the people who appoint know you. And therefore, if you really want to achieve your first arbitrator appointment, try to find out with which institutions you could qualify as an arbitrator. Try to find out who appoints the arbitrator or suggests the arbitrators, and we will come to that a bit later, and then just make sure that these people know you. I got my first appointment, I think, at age 35. So I was a bit older than Paolo. And it was just a recommendation by a colleague. At the time, it was a very small case. And this same colleague, who got older as I did in the meantime, now appoints me for very large cases. So this is really how you then develop together with your community, with your peers. And therefore, I think it's just important to network with your peers. It's also more fun to do so when you're younger. It's more fun and easier to network with your generation. And then naturally you get older and the cases grow, and this is how your career can develop. And then with your first appointments, the first challenges may show up. When I look back, my first cases were the smallest cases, but at the same time, the most difficult cases. And this is because these first cases you get are often sole arbitrator appointments. So you are alone. You have no co-arbitrators to discuss the case with. And often, because the amount in dispute is so small, you also have counsel who may not have that much experience in arbitration. So you don't have the very professional pleadings. You, as an arbitrator, have to sometimes educate the parties and the counsel, and this may lead to very tricky situations. So I would be interested to hear from you, Paolo. How were your first experiences as an arbitrator? Did you face any challenges there?
Oh, yes, for sure. And I think that one of the challenges that I faced back then still is a challenge which I'm facing today, which I'm much older, which is the cultural difference when it comes to legal backgrounds. I remember that in the very first case I was involved, there was a Chinese party versus a Swiss party. And there was quite of a challenge in terms of legal differences and legal perception of what should be done during an arbitration. And when you're very young, but even when you're older, I mean, sometimes it's not that easy to bridge the gap between the differences. Then I think that if you are lucky enough when you get the first appointment, you are already sufficiently equipped in terms of experience sometimes. I have the impression that maybe nowadays arbitration appointments tend to come pretty early in the career of younger generation, and that can be a further hurdle, particularly if the person in question has no chance to discuss internally with somebody in the law firm when there is need for help. And sometimes it's very good to have somebody to whom you can turn to and ask an advice in difficult situations. But again, as tips, I would say that first of all, it's very important to be organized when you receive the new case, and that applies when you're younger, but also when you're older. And then the difficulty that you may have, particularly when you have a distinction between appointments or first appointments as co-arbitrator, president is far more rare, or as a sole arbitrator, is to establish authority. And establish authority, you have to establish within your tribunal, if you are in a free-member tribunal, or authority with the parties when you're acting as sole arbitrator or as a chair. Then I think a good tip is to have a good relationship with the administering institutions. I remember that when I was counsel at the Milan Chamber of Arbitration, the arbitrators that we hated were the arbitrators who were behaving badly with counsel. So still today, I don't understand why an arbitrator would treat badly counsel in institution. That's a very non-smart move, if I can put it this way. Again, as I said, don't be afraid to seek help internally in your law firm, of course. How to overcome these challenges? Preparation is the key. So the most important advice I would give to younger generation is that when you get an appointment, even if it's a small case, it's the most important case that you may have. So the better thing that you can do is just to be prepared and show that you are prepared to the parties and to your co-arbitrators, if there are co-arbitrators. Now, maybe we can say a few words, Nadia, on the selection process. I'm involved in the Swiss Arbitration Center, of course, and you're involved in the ICC Swiss Committee. Shall I go first or? Okay, perfect. So, well, at the Swiss Arbitration Center, I would say that the appointments of arbitrators directly by the institution is more of an exception than the norm. Most of the time, parties appoint their arbitrators directly, including the president of the arbitral tribunal. This is normally done by the co-arbitrators in consultation with the parties. But that being said, when appointments are made directly by the institution, and I'm involved in the selection process, in many cases I've been involved, The most important thing is the quality of the candidate. So we try, and as much as possible, to have good arbitrators, because good arbitrators is the benchmark against which the quality of an institution is tested in general terms. When I say quality, I may also include, well, diversity. But diversity should not be intended only in terms of gender, but also in terms of legal background. So we're not just focusing in appointing Swiss arbitrators. That would not be the good way to go. Because in particular, what we are doing is actually administering international cases. As Urs pointed out, the statistics are pretty clear. 78% of the cases are international, which means that at least one of the parties is not a Swiss party. Again, how to be appointed? Again, you have to be known or to the institutions. So one of the things that I would suggest to do is sending a CV, and again, participates in events which are organized by the Swiss Arbitration Association and the Swiss Arbitration Center. That's key in order to become part of the radar, within the radar of those who will make the appointments. Nadia, your turn for the ICC Swiss Committee.
Yes, so with the ICC, typically an arbitrator is also appointed by the parties, but there are still many cases where the parties cannot agree on an arbitrator, either on a chair or on a sole arbitrator, and then the institution appoints. There are sometimes direct appointments by the ICC in Paris. And then if Paris does not directly appoint, they would typically ask a ICC national committee to make suggestions to Paris. And there is where I would get involved as a member of this commission in Switzerland, who is involved in making these suggestions. In Switzerland, we are 4 members in this committee. And for each appointment where the ICC in Paris would ask Switzerland for proposals, always one of the 4 members, would propose 3 names, and these are then sent to Paris. So as mentioned, we are 4 members. 2 are based in Geneva, 2 are based in Zurich. And it, of course, depends on a case. Paris would typically tell us what we the arbitrator should have. And then we would typically look at the amount in dispute, we would look into the background, the arbitrator needs, of course, on the applicable law. Language, of course, is very important. So if the arbitration is in Italian, you need another arbitrator compared to a case where an arbitrator needs to know English law, for example. And then, as Paolo mentioned, it's of course important for you, if you want to be appointed, that these commission members know you. So I would personally hope that all the young practitioners in Switzerland who hope to be appointed or think they're qualified to be appointed at some point reach out to us, just send their CVs and tell us their qualifications and that they are interested in sitting as an arbitrator. In Switzerland, you do not need to be Swiss to be appointed or suggested, but you can also be based in Switzerland. So as the ICC Swiss Commission, we appoint either practitioners based in Switzerland and or being Swiss nationals. I think that's also important to know. And now for you as a Ukrainian practitioner, I think it's just important to find out where, of course, you practice, and then for which institutions you may qualify. Of course, you qualify for ICC arbitrations, but if you're not based in Switzerland, it is for you more interesting, for example, to be appointed directly by Paris or by the national committee where you practice. And I think there it's just advisable to do some research to see where are for you the most important and interesting entry points to get to these appointments.
May I add here one note? Actually, the ICES website contains a page about nomination commissions or whatever. I mean, it could be named differently in different jurisdictions, but normally there is a names of all the persons involved, and this is important in all the jurisdictions, and this is important to figure out whom to contact at least or to approach with this regard. Thank you.
Absolutely, and sometimes there are lists. For example, in Switzerland, we do have a list, but it's not a closed list, so you do not need to be on the list in order to be suggested, but it is, of course, useful, because whenever I have a case, I want to do my job, so to speak, and just find the best person that qualifies for this particular case, and then it's important that at that moment you get across the names you need. If you then are on the list, this may help, or if you have made sure that these committee members do know you, this of course helps as well. Diversity is very important, I think, for the ICC, but also for the Swiss Center and probably all the other institutions as well. I could say as a woman, it's now really the chance of women in arbitration right now, because most of the institutions and also the parties, I should say, are really interested in appointing women. So it's a great time for women to start a career in arbitration, in my view.
Maybe I can add something that you both so far did not mention, in my view, how to really start to get your name known. You mentioned the moot courts and also to go to conferences. But if you go to conferences, you should make sure as soon as possible that you also get a speaker slot. So just to go there and participate usually does not help that much. So you need to try to get contact to those persons who organize a conference, and then try to get into maybe not the one that you first start, but next time that you get a speaker slot somewhere. And I think also today, all major institutions or organizations have these young organizations for young practitioners. So we have in Switzerland ASA below 40, you have the ICC YAF, or maybe it's also below 40 now, I think they changed their name. So you find in all organizations and institutions today, they have specific organizations for younger people. And that's a good point to start first, to build up your network among those who are your age, and then you can grow together. And it's also easier to get in there for a speaker slot than in the conferences where the old guys, old men and women are. That maybe they're a little bit more difficult. And for instance, one I would also like to mention is the AISA. The AISA is really a very good organization, in particular also in dispute resolution. It's I think, Nadia, you were, I think, also active in this, if I remember correctly, because I know Dani Hochstrasser, your former, he was very active in AISA, so I think he would support that. This is really a good network. And also publications is something that you should do. There are so many journals today of all institutions. And if you find a good topic to make a publication, or just a short discussion on a court case in your country, for instance, if in Switzerland we have these Supreme Court cases in arbitration, and then all law firms try to make as quick as possible a short comment on it, that you see that they have seen this. So these are all things that you can try to make your name known then to those people who are involved in these institutions, and in the end, and also obviously those who are counsel in arbitrations, who try to find then other practitioners as arbitrators.
Maybe there is one point that we did not touch upon, and it would be nice to hear the views of Nadia, and of course also Urs can step in. So maybe it's the takeaways that you may have as counsel by sitting as arbitrator. So it is quite important in my view, because sometimes we say in order to become a good, and we've said beforehand, in order to become a good arbitrator, you have to be a lawyer first, or develop a good practice as lawyer. But you may also be a better lawyer if you sit as arbitrator. So it's two sides of the same coin to a certain extent. And I wanted to share with you a recent experience that I had in this respect, because I was asked in my role of international arbitrator to be involved in the study that a big company did on past recent cases in which I was not involved. The outcome of those cases was not satisfactory to that company, and I was asked to look at the files with a fresh eye, but with the eye of the arbitrator, in order to point which aspects in the case presentation that they've made could have been going another direction had they thought differently with the eyes of an arbitrator. And that was a very interesting experience, because sometimes when we sit as arbitrator, we can actually correct our way of behaving as counsel in order to try and minimize the biases that we have as arbitrator in the decision-making process, which is something that very much is dear to my heart. I've written articles in this respect, and these biases cannot be completely eliminated in my view, but they can be kept under control to a certain extent by using certain techniques in the presentation of your case, in writing or orally, in behaving or interacting with the opposing counsel, etc., etc. So I really believe that it's very important also for your practice as counsel to be able to sit one day as arbitrator. And I'm really hoping to hear Nadia's and Wolf's views in this respect.
Yeah, I fully agree with that. And I think really one of the greatest benefits of sitting as an arbitrator is really to learn and to benefit for your practice as a counsel as well. And I mean, the greatest benefits in my view for my counsel work are case assessment, as you also just mentioned, Paolo. I think I got much better in assessing cases in an objective way since I have experience as an arbitrator. Because if at the outset of the case, a client asks me to do a case assessment, I put on my arbitrator hat, so to speak. So I really try to look at the case as an arbitrator and try to predict how a tribunal will decide this case. And to me, a case is won in the end for the client if I overachieve my initial case assessment. So it's not necessary to win in full if you told the client at the outset of the case that you might lose with a high percentage a certain part of the case, because if you do so and the client decides to go on and then you achieve that and maybe even more, the case is won in my view. And then second point you learn as an arbitrator is just how to behave as a counsel, because you see it from the other side. I think I got less aggressive based on my experience as a tribunal member, because I just see that it's not always very effective to be aggressive, but it may really be much more effective to choose your battles, to know where you want to be aggressive, but only on very specific points which are very important for your position, and for the rest you don't do that. And then last point is just to see your role as counsel to help the tribunal understand the case. So again, you must try to put yourselves in the shoes of the arbitrators and to help them understand the case, and really think about how to make their lives as easy as possible, because they're busy people, don't have too much time to read the case. So make sure they get the most important points, make sure it's easy for them to understand the expert reports, help them to do so, and so on. And last point, this also helps me for my litigation cases in state courts, because there it's basically the same. So I think arbitrator work is really beneficial to your entire practice as a counsel.
I can fully subscribe everything that Nadia just mentioned, and also what you said, Paolo. And one thing I would like to add is really that you need to be, in particular for the hearings, you need to be really good prepared, because I'm only working as an arbitrator since some years now, and you see it immediately as arbitrator if a counsel is really on top of the case. And this also means sometimes it's better to have less witnesses than more, but only the good witnesses. Because I just had a 3-week hearing in September, and I would say half of the witnesses were not necessary. There were 26 witnesses and 12 experts. And you're shaking your head, Olena. It was only a third of all the witnesses. There are 2 more hearings. They have 76 witnesses in this case and 35 experts. So I suggest them to cut it down, because in particular, experts were not really helpful, some of them, and this really doesn't make a good impression. So you learn that you really, sometimes less is more, is better than more. And I think as counsel, you maybe think you want to present as much as possible, but in connection with witnesses and experts, this can be really difficult and dangerous, even dangerous. And not being aggressive, Nadia, that's exactly what I think, or only in very few moments when you really think now it's not good anymore then, but not as a general habit to have an aggressive appearance. That's really something I don't like at all as arbitrator. And so, yes, you're not tougher if you're aggressive. If you know that if you're on top of the case, that's the best thing to really make impression in front of a tribunal.
Thank you all for your comments. So indeed, the arbitrator's experience could open some new chapters, in your professional activity. And I remember a couple of cases, so a couple of years ago, I was asked by a client to look at their potential case, but not as a counsel, but like being in the shoes of the arbitrator. I mean, looking, not favorably on the client's position, but looking more objectively for them to decide whether to pursue a claim or not, because the client's team was quite, optimistic, so to say, with their case, which was not necessarily so. That was a very interesting experience. And I also had this similar experience on looking at someone else's case for the client where I was not involved at all, and trying to understand what was done not good enough and why the case was lost. Yeah, so and that might give you quite different insights indeed on an understanding what was going on behind, what was not visible for the counsel, and probably what indeed influences the tribunal's decision. So it's indeed very, very interesting, and it has effect on your behavior as counsel. I see that we do not have many questions, so probably I will ask you to give a small advice. I mean, you have already told a lot, but to Ukrainians, to young practitioners who are just starting their career, and to young arbitrators who have already had some appointments, some words what they could do right now or in long perspective to improve their performance as arbitrators and their chances to be appointed more often. I mean, again, a lot have been said. We could just summarize something of you've already told us. Who would like to start? Paola?
Yeah, I think that I'd like to answer this question by taking a slightly detour, if you allow me. I'm an Italian national. I'm an Italian national which has built his career outside of my own jurisdiction. in Switzerland, in particular, in arbitration. So maybe what I can say is what I found beneficial for me, which can be applied also to Ukrainian practitioners of arbitration, which are called to practice law internationally, not only in Ukraine and outside Ukraine. So to a certain extent, for me, it was important to be recognized by the locals as part of the community, to a certain extent. And this is not something which you gain in over a fortnight or a couple of weeks. So it takes time. It takes time. You have to learn the people, to understand the behavior, to understand the practice. And I think that's fundamental to be accepted as part of the community. And I think that applies also to those who are willing to apply or to practice arbitration internationally, because irrespective of where you come from, you have to be accepted to a certain extent as part of the community in the way you behave, in the way you practice the law, in the manner in which you represent your clients, and so on and so forth. And for Ukrainians, it's exactly as it was for me. So we need to build up our international practice, be rooted in our own jurisdiction, but with our eyes, our mind open to other cultures, open to other influences, whether substantive or procedural. So that is my biggest advice, which is not an advice to get new cases, of course, but just of a mindset approach. And I think mindset drives you in whatever you do in your life, not only in arbitration.
Yeah, thank you, Paulo. This is indeed true for now many Ukrainians who have been forced to leave Ukraine or decided to do that irrespective of the war. But indeed, we have this issue now. Nadia?
Yeah, I mean, my tips would be very similar. First, quality of work. Just try wherever you are and whatever you do, try to provide the best quality you can at the stage of your career where you are. And then second, care about people. The community is very small. You always meet twice or even more time. So in whatever function you meet someone, treat people kindly. This, of course, applies general in life, but in particular within the arbitration community, you may meet someone now whom you meet again in 20 years and you're in a case together. And this is really important. And then last point, be patient. A lot is just coincidence and luck, and you can help your luck a bit with hard work and everything you do. But yeah, be patient. Things will develop if you stick there and work hard. I'm sure things will develop in a positive way.
Thank you, Nadia. Thank you. Urs?
Yes, what I would add is, I mean, we are in international arbitration, and it is the goal to be active very internationally. But in the end, you realize that a lot of cases still stay in your region, at least with regard to the seat of the arbitration. I had arbitrations quite far away as well, but if I look at my cases in the last 20 years, a large majority of the cases, in the end, the seat was in Zurich or in Geneva or in one city in the neighboring countries, and only a smaller number of the cases really far away. So that would mean for practitioners from Ukraine, I think if you look around, what other countries are there in Eastern Europe who have arbitration institutions, and there are many. There are many that you could also try to build up your network with these, because in the end, it's very likely that you will have cases that are somehow related to your region as well. So that you really have very remote cases that have nothing to do with where you come from is rather rare. And maybe the the most famous arbitrators in the end, they have done such cases, but most of us have cases that are really somehow related to your jurisdiction. And so I think to build up the network in the region is very helpful as well. And obviously, I would recommend all who can travel and who can, I must say, also afford it, because it's not so cheap to come to the Swiss Arbitration Academy. But there is also a grant for 1 or 2 person to come. And so if you have a chance, and I mean also if you are allowed to travel and can travel, then you should try to do that, to go to such places.
Thank you very much, Urs. I could only add, probably building on your comment about the region. So, in fact, Ukrainian arbitrators or practitioners could consider joining regional associations as well in arbitration. So there is one, ARPC, for Central and Eastern Europe, which is, I mean, Ukraine, of course, is in Eastern Europe, but because of the Soviet past, Ukrainians could also consider joining Turkic Arbitration Association, which actually unites Central Asia countries, which were many years ago part of the same country. And again, this is just an example. There are, of course, many others. And actually, Swiss Arbitration Association is a good example of a very efficient professional association. And if Ukrainians are interested in this jurisdiction, that is definitely an association to join. For all the purposes you've just mentioned. So thank you very much for your time. Thank you very much to the Swiss Arbitration Association for helping us to organize this event and sharing your valuable insights and experience with the Ukrainian audience. And not only Ukrainian, actually, during our webinar, I have received some messages from other jurisdictions that they are watching us as well. So I hope that would be useful for all the participants from different jurisdictions. So thank you very much.
And thank you very much, Elena.
Participants for being with us. Thank you.
Thank you very much.
Thank you, Elena. It was a great pleasure.
Yeah.
Thank you. Bye-bye.
Bye. Thank you.